was always something exciting and compelling to do in this place.
When I arrived here in the Department of Justice, I suddenly had an incredible opportunity.
J'étais vraiment contente de pouvoir rentrer au sein du ministère de la Justice.
There was no case like it in the Supreme Court.
There just seemed to be a momentum to get things done.
My name is Robert Frater, and I'm Chief General Counsel at the Department of Justice. This was the first big case I did. It was a fascinating thing to go back into the records of time. The Milgaard reference occurred in 1992 in the Supreme Court. This case was about whether David Milgaard had been wrongfully convicted of murder in Saskatchewan many years ago. So in the fall of 1991, there was increasing pressure on the Minister of Justice to do something about the case because many people felt that Milgaard had been wrongfully convicted. The government's solution was to launch this reference in the Supreme Court. And from a litigation point of view, it was highly unusual because what it involved was hearing live witnesses before the Supreme Court, something that they hadn't done since the Stephen Truscott case in 1967, and it turned out to be quite a show. We heard from a lot of witnesses who had testified at trial, and not everything went smoothly, partly because the witnesses turned out to be a very colorful assortment of characters, and they said odd things. At the time that this reference took place, the DNA testing was really just getting going. And in fact, Mr. Milgaard didn't get his exoneration from that reference. The one thing we could say for certain at the end of the Milgaard hearing was that you wouldn't have convicted Mr. Milgaard on the testimony of those people today. There was no case like it in the Supreme Court. I think it had an important impact in changing attitudes about the possibility of miscarriages in our criminal justice system. It really served to kickstart the entire movement to investigation of wrongful convictions in this country. And I think without that hearing and the attention that it brought to Mr. Milgaard's particular case, that may not have happened.